You recently left corporate America to start your own business, and you now have received a letter from your former employer reminding you of your non-compete obligations. This is Jonathan Page. We have helped numerous entrepreneurs successfully navigate their post-employment restrictive covenants and then scale their business fast and with confidence. Here is the number one. First thing you must do: verify you actually have a non-compete. On more than one occasion, we have had clients send us their prior employment agreements, and after a quick review, what they thought was a non-compete was not actually a non-compete. There are four main restrictive covenants that might appear in your employment agreement. The first is a non-disclosure. This provision prohibits you from disclosing your former employer's confidential information. The second is a non-solicitation of employees. This provision prohibits you from soliciting other employers that worked with you at your former employer. The third is a non-solicitation of customers. This provision is often confused with a non-compete. This provision prohibits you from soliciting your former employer's customers. Importantly, it typically includes prospective clients too. There is a limit. Most states limit this restrictive covenant to customers or prospective customers in which you had a material contact, meaning you had developed some sort of relationship with this customer or prospective customer. You spoke to them on the phone. You helped convert them into a client. You helped service the customer's account. That's material. And finally, there is a non-compete. This is what a non-compete looks like. During the term and for a period of 2 years, absolutely critical, there is a restricted period, so it doesn't last forever. Now, this is also typical of a non-solicitation of customers and a non-solicitation of employees, and sometimes a non-disclosure. So this can get confusing when you're looking at your employment agreement, because you might see a restrictive covenant, but that doesn't restricted period, but that doesn't necessarily mean that you have a non-compete. Here's what makes it a non-compete. So we could substitute this for employee. Yes, non-competes can apply to contractors, not just employees, but in this case, you're a former employee. You will not engage in any prohibited activity for a competing business that is in a business within the restricted territory. Okay? So there's three components. There's the duration, right? The period after your employment was terminated. There's the prohibited activity. This is the activity that you must not engage in within a specific territory. So what makes this different than your non-solicitation of customers is that it has nothing to do with actually soliciting customers. It has nothing to do with actually soliciting employees. It's simply saying if there's a competitor within this territory, you can't work for them. Or the other thing that it'll include is that you can't own, manage, or control a competing business. This is what prohibits you from starting your own company to compete with your former employer. It also includes a definition of prohibited activity. Absolutely critical. Typically, when you're looking at this definition, the concern is you doing a job that is similar to the job that you did for the former employer. So you'll see other similar capacity. And this is also critical because it's this restriction or this limit is also typically under state law as well. So the former employee must limit it to activities that were similar to the activities that you performed for them. Otherwise, the law or court may find that they're overreaching and then invalidate the restrictive covenant. And then finally, there's this competing business, right? A competing business is one that is the same or similar business as the company, as your former employer. So if you go to work for a completely different company that's within a completely different industry, that's not going to apply to your restrictive covenant. And that, again, is a limit that's under state law. And then, of course, they've got the restricted territory, which we discussed. In this case, we have a 12-mile radius. That is not the only way that you can identify a restricted territory in a non-compete. It might also be the entire United States or it may be specific states. Again, the former employer must comply with state law, and under state law, there must be a legitimate business reason for establishing the territory. So if your former employer only did business in Georgia, but their non-compete includes the entire United States, that may be a reason to invalidate it. But again, if you want to actually verify that there's a non-compete in there, don't stop with the restricted duration. Don't stop with the restricted period. Make sure that there's these other components in there so that you're actually dealing with a non-compete. This is Jonathan Page, and I will talk to you soon.